In today's video, we will talk about defense attorneys in the American criminal justice system. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice or working in the legal or law enforcement fields need to know what defense attorneys do in the American criminal justice system because the reality is very different from how defense lawyers are portrayed in TV shows and movies. The media often distorts or misrepresents the criminal justice system to get higher ratings. Today we will talk about the reality of the role of defense lawyers in criminal cases. Defense attorneys play an important role in the American criminal justice system. Indigent defendants in felony criminal cases have the right to court-appointed counsel. Indigent means they can't afford to pay for their own lawyer. In the case of Gideon v. Wainwright, 1963, the U.S. Supreme Court ruled that the defendant should have received a court-appointed defense lawyer. He had requested one at the trial level but had been refused. He got convicted and he appealed and said that he should have been represented by a court-appointed defense lawyer. The right to defend yourself from criminal charges should not only be available to people who are wealthy. In America, we have constitutional protections from government misconduct. Those protections depend on defense lawyers to challenge illegal arrests and evidence that's obtained improperly. If a defendant does not have a defense lawyer, their rights that may have been violated will go unchallenged because your average citizen does not know all of their constitutional rights that apply to criminal proceedings. So the right to court-appointed counsel is essential to the effectiveness of our constitutional protections. In the case of Gault, 1967, the right to court-appointed counsel was extended to include juveniles. People often have questions about the right to court-appointed counsel. First one is usually, hey, when do I get a defense lawyer? At what point in the criminal process does my right to court-appointed defense counsel begin? Is there a right to court-appointed counsel in every criminal case or only in felonies? Can criminal defendants waive their right to have a lawyer and represent themselves instead? And what happens when the defendant thinks that the defense lawyer was incompetent or ineffective? Let's take these one by one. First, the question of at what point in the criminal case does the right to appointed counsel start? Usually, a person has a right to appointed counsel at the time that they are in custody, meaning they're not free to go, and they're being interrogated. So, for custodial interrogations, the defendant has a right to have a lawyer present. This is when adversarial proceedings have started. That's usually what counts as starting the adversarial proceedings, the custodial interrogation. And it's not that they only have the right to a court-appointed lawyer in the interrogation and then they're on their own. The right to appointed counsel applies to all critical stages of the case. Question 2. Is there a right to appointed counsel in every criminal case or only in felonies? The answer is that the defendant is entitled to appointed counsel in cases that involve felonies, misdemeanors in which a jail sentence is imposed, whether it's an active or a suspended sentence, when the defendant is appealing a conviction, and in cases that involve juvenile delinquency. Third question. Can criminal defendants represent themselves? Yes and no. Criminal defendants do have a right under the Sixth Amendment to self-representation, but first they must show the judge that they know how to conduct a trial, and standby counsel must be available during the trial in case the judge sees that the person really doesn't know what they're doing and that they would be unlikely to receive a fair trial, a fair defense as a result. And question 4, what happens when the defendant thinks the defense lawyer was incompetent or ineffective? Usually, the court views these claims with great suspicion because ineffective assistance of counsel complaints get filed after almost every criminal conviction. So it almost seems as if it's a formality, but nothing substantive behind it. However, the appellate court must reverse if, because of the lawyer's actions or failure to act, the trial proceedings were unfair and that the outcome would have been different if counsel had not been ineffective. That's important, the "and" in that sentence, because even if the trial proceedings were grossly unfair, if the jury still would have convicted the defendant, in other words, the outcome would not have been different, the appellate court will not reverse the conviction. And who is eligible for a free appointed defense lawyer? Indigent defendants are eligible. As I already stated earlier, indigent means they cannot afford to pay for their own lawyer. Well, that includes a whole lot of the general public, but in particular, people who rely on government financial assistance are considered indigent for this purpose. Now, people can also be found indigent by the court and eligible for a free appointed defense lawyer based on their income, even if they do not receive government financial assistance. About 3 out of 4 state prison inmates do have a court-appointed attorney. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results. The higher these videos are in the results, the more people I can help. Thank you. There are multiple systems of providing indigent defendants with attorneys. Counties get to choose which type of system they will use to provide free defense counsel to indigent defendants. The 3 main systems are assigned counsel. In small counties, they might not have a particular individual whose job is to be the public defender. So in those places, the judge might appoint a specific lawyer on a case-by-case basis. Also common in small counties is a contract system in which private attorneys get hired to serve as defense lawyers for a specified price. For example, A young lawyer who's building their practice might, in order to supplement the income they're making from their own cases, they might try to get on the county's list of contract lawyers, and the specified price is usually an hourly rate. It's usually a rather low hourly rate, which is why it's usually young lawyers who are trying to build their practice. And then there are public defenders. They work as public officials for a salary. They don't get to pick and choose who they represent. Everyone who comes into the public defender's office as eligible for appointed counsel will end up in the workload of one of the public defenders. These are people who usually work full-time for a flat salary, no matter how many people they represent. The problems with all three of these systems for appointing counsel is that they're usually paid far less than they should be, and they usually have a pretty onerous workload. So they're overworked and underpaid, and we all know how that can affect an outcome. Now, whether they are private criminal defense lawyers or some form of public or otherwise publicly funded criminal defense lawyer, they all have ethical duties, including confidentiality, meaning they're not allowed to go around and tell their clients secrets. People have to disclose a lot of information, very private, personal information, when they have a lawsuit in court, when they're a defendant, and defense lawyers are not allowed to just take that information about their clients and gossip. Confidentiality is one of the high ethical duties of any lawyer. Also, the ethical duty to act with reasonable diligence. It's not enough just to show up at court. Defense lawyers are supposed to perform a reasonable investigation and do legal research, formulate a trial strategy, and basically just work hard on behalf of their client to try to get the best possible outcome. That is also part of the next ethical duty, which is zealous representation. Now, zealous representation is within the ethical bounds. That does not mean that they have a duty or even any right to commit fraud or perjury or to fake evidence or alter evidence. That is overzealous representation, and that is an ethical violation. Also, defense lawyers are required by the ethical duties to abide by the client's decision. In other words, if the client wants to accept a plea bargain because they're terrified of going to court, the lawyer has to abide by that decision. They can't force the case to trial. They must also keep the client reasonably informed, so the defense lawyers should never be in a position after a case in which the client, defendant, found out after the fact that the prosecutor had offered a plea bargain and the defense lawyer never bothered to tell the client. Now, the defense lawyer might have thought that it was a terrible deal for the client, but that's for the client to decide. The client is supposed to be reasonably informed of all settlement offers. And finally, defense lawyers have the ethical duty to avoid conflicts of interest. So if there is anyone involved in the case who is close to the defense lawyer, or any other aspect of the case that would be a conflict of interest, the defense lawyer should excuse themselves from the case and seek permission from the judge to withdraw. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video called "What Do Judges Do in Criminal Courts?"